I'm Bob Stannard. I want to welcome you to our seminar on contract negotiations. Richard Brown is Vice President and Chairman of our planning group. He will introduce our speaker for today. Richard?
Okay, thank you, Bob. Well, hi guys and dolls, ladies, excuse me. I'd just like to welcome everyone here. We're going to get right into our program because Judith has a contract that she wants to go over. I'd like to thank her before we break, just in case I forget to later. This is the first time that we've had two seminars or conferences that related to the same type of material, and Judith is the first person that's been involved with us for this kind of duration and time. So let me go over just a couple of things while I'm thinking about it. Bob, you can kind of keep tabs and make sure I don't forget everything. I think everyone was given two pieces of paper. One is sort of a cover sheet and one is a blank contract that Judith is going to go over. Everyone should have received a couple of note cards to write questions in case there's something that isn't covered in the presentation. If you will just write your question down and pass them up to the front to me at the end of Judith's presentation, I'll read them or she'll read them, and we'll do like we did last time. We're going to take a break halfway through, and I guess without any further ado, we'd like to welcome for the second time to ASFD to help us with our legal needs, Ms. Judith Garmon.
Richard, on the question cards, if they come in, last time you kind of grouped them together, if there were identical questions, that really helped a lot.
I'll try to screen them.
If we can do that again. Hi. How's market going?
Just starting.
I know. You've got to have a gut reaction. That happens very quickly. Am I
don't think your microphone is on.
Is it?
Yeah, it's on. Talk into it.
Am I your...
That's fine.
Okay. I've been told please don't move around the room, and that's tough for me because I have a habit of walking as I talk. So if I veer off course, someone please tell me. I'm out of the range of the video. Getting right into the subject matter so that we don't waste any time. If you will look first at the single sheet of paper, this is a little bit of a recap of our previous seminar. It's a listing of what I feel are the...
Of course. One of the spotlights is hitting the picture. It's making
That's all that.
Okay.
Usually the glare rule only applies to me.
I don't know, white hair will do about the same thing. Okay. At the previous seminar, we discussed the various types of contracts that are applicable to designers. And I emphasized a feeling that designers should expect to be treated with the respect that is represented by a well-negotiated contract. It's my understanding that frequently you go in somewhat hand in hand and say, I have these wonderful designs, would you please look at them and please consider adding them to your line? And there is a way to do that, of course, but you also need to protect yourself because many times the potential buyer will see the validity and the quality of the designs and begin automatically anticipating how they might be obtained without sufficient payment to the designer. That's a negative statement, I realize, but it's also a very accurate statement because let's face it, we all want to get the maximum for our dollar. Can you hear me in the back? Still not? Am I still not? Pardon?
It should be a little louder, I believe.
How do we turn this up? Richard?
Yes.
Are you a mechanic? I'm only a patent attorney. I don't know about these things.
What's the problem?
They say they can't hear me in the back. Is this better?
Yes.
Is that better
Get
now?
closer to your mouth.
Okay. I am used to walking and not having the mic right in front of me. I'm sorry. All right. back to the list. The first thing I would suggest, and we're going to quickly just recap this, is at the very minimum you request a confidentiality agreement before you open your portfolio. This type of agreement merely obtains the stipulation that your portfolio will be reviewed and that it will not be revealed or used by the potential buyer without further remuneration to you or further agreement from you. It's a very basic contract. We're not going to go into the details of that today. The second would be a contract relating to design services, and I think a number of you probably already use this type of contract. It may be a retainer basis. Maybe someone comes to you and suggests or requests that you do a grouping or a piece of furniture, a particular style, a particular design, and you negotiate this contract specifically related to what you are going to provide and what you're going to be paid for these design services. I'll skip to the fourth one, which is the assignment of any patents that you might obtain or might be attempting to obtain. The thing I want to say about assignments is that you recognize the difference between an assignment of a patent or a design, and generally this is of a patent. Most times you don't assign design rights. It can be done, but that's more a rarity. Assignments generally exist where you have a design for which you are seeking patent protection through either utility patents or design patents, or you have already obtained these patents and the potential buyer, manufacturer, whomever is interested in getting the full right and title to that design. And that is the key that you need to remember. 99.9% of the time when you grant an assignment of your patent, that's the last you're going to see of it, because you are granting full right and title to the invention protected thereunder. And you need to recognize that that is different from a license to manufacture, to sell, and under which license you will be paid a royalty. Now, for assignments, you might be paid a royalty or you might be paid a lump sum. All of those types of things are negotiable, but the key thing that you lose through an assignment is the right and the title. So if you're interested in retaining that, you want to look at number 3 on the list, which is the license. And that is what you were given in blank form in the second handout. And I want to start with this license agreement, and we will go through it paragraph by paragraph, giving you initially the caveat to this effect. Although there are many books published in the United States on a routine basis, how to incorporate your own business, how to draft your own wills, how to do this, how to do that. This is not what this is intended to be. I do not believe in form contracts where you merely fill in the blank. I know they're used frequently and they're not always bad, but they are somewhat dangerous because no set of circumstances, whether you're negotiating a royalty agreement for a piece of furniture that you designed, no set of circumstances is going to be identical to the immediately preceding set of circumstances. So no form contract is going to automatically protect you in every instance. The contract that you have in front of you is drafted from the standpoint of protecting the minimum protection that I think you as a designer should expect. And when I'm saying you as a designer, if there are manufacturers in here, I apologize, but I'm also aware that you're going to have designers on your staff, and you may at some point be selling to other people. So this is where I'm coming from, and it is therefore drafted with a slight bias to the designer. It is, however, drafted such that it should not be offensive to any potential buyer or manufacturer and should not automatically alienate them once they sit down to read it. The best case circumstance is a win-win negotiation where both parties come to the table and both parties provide input to a given project, working as partners with both coming out winners, so that you don't negotiate a contract from a win-lose perspective. I sit down and I win everything I can and my opponent's going to lose. That's very old hat and going to be very unacceptable in most business circumstances. So that's where we're coming from in this contract. It's a very basic contract. It should suffice for many, many circumstances, but I don't want you to go out of here with the feeling that it answers all questions and that there are not sections of the contract that would or could or should be negotiated anew with each business deal. That said, let's start with the first paragraph. It says, this agreement effective as of. Now that sounds very simple, but there are questions that arise as to when contracts go into effect. I have put this paragraph in with a specific effective date to eliminate the possibility down the road of there being questions as to when the contract actually went into effect. Was it when the first party signed, when both parties signed, when the second party signed and put it in the mail, when the second party signed, put it in the mail, and the receiver received it? When did it become effective? And that can at times become a real key issue. So the effective date of this contract is the date that's filled in on line 1, regardless of the dates that it's signed. That's the simplest way to eliminate future problems there. By and between the designer having a place of business at, hereinafter referred to as the licensor. You own the design or the grouping that you are trying to sell, so you are the one granting the license. You are the licensor. The buyer, manufacturer, seller, whomever is the licensee. Second paragraph, licensor has created certain unique designs for furniture, including design sketches, working drawings, other such materials considered to be proprietary information. This is a minimum. As I understand from conversations with certain ones of you, you may provide something as basic as perspective drawings of your design, right up through working drawings, engineering drawings, how-to manuals. You may give consultation, advice, engineering support on the manufacturing of a particular piece. All of that should be spelled out early in the contract. Exactly what are you agreeing to provide to the manufacturer? What type of consultation and support will you provide beyond the contract? You don't want to get midstream and find out that you are not only going to be providing the design itself, but you're going to be providing the know-how to get this design manufactured, but you're not going to be paid additionally for that know-how. Now, this contract has only 1 or 2 royalty provisions related to it. As I said, it's a very simple, very basic contract. But if you are providing a lot of know-how and proprietary information, particularly if it even falls within the area of trade secrets, and this happens in the furniture industry more than you might realize, where if you have designed, for instance, or invented new resin compositions that, when properly cured and finished, look identical to wood, that knowledge might be quite valuable to a manufacturer who does not have that knowledge. So if you are going to be supplying additional production consultation. You want that spelled out, and you want that included in your royalty. Now, it might be included in a separate royalty paragraph where I will be paid X amount, X percentage for my design. That might be paid over the period of the entire manufacturing period, or there might be, as I understand, it's becoming a prevalent practice, a cap on a number of years. We'll talk about that later. But secondarily, if you're providing the startup and the know-how on some additional manufacturing procedures, then you should be paid a separate royalty or a separate consultation fee for that knowledge. So that is the first area, this paragraph 3, that might be subject to negotiation, and you want to spell out early in the contract exactly what you are giving up in return for payment of the royalty. Excuse me. Skipping now to paragraph number 1, which is the granting clause. Licensor hereby grants, and licensee hereby accepts a non-transferable exclusive license for a period of 3 years from the date herein above. Now let's stop right there. There are 3 key words in this one paragraph that you need to be open to negotiate. The first one is non-transferable. And I will touch on that a little bit more when we get to paragraph 2. But essentially what it is saying is whether or not the licensee has the right to transfer his rights and obligations under this contract to a third party. And that's not something that should be treated lightly. There are many things that could affect your desire to have a license transferable. So in most instances, when I draft a license agreement, I make them non-transferable, absent some further stipulation. This is also, in that same line, you will see the word exclusive license. This is opposed, of course, to non-exclusive. A non-exclusive license is the circumstance or instance where you as a designer will let numbers of people or manufacturers manufacture your design or produce your design. This is something that you have a right to do if you can obtain production without granting a manufacturer an exclusive license. But in most instances, a manufacturer is going to want and should want an exclusive. In return for that exclusive, they pay certain royalties that would be over and above the royalty payable on a non-exclusive. But that is one decision that should be made prior to going into the negotiation of contract, is exactly what do you want? Do you want one top name, well-known manufacturer to add this to their line? If so, then you can expect to have to grant an exclusive. If you want the ability to have others manufacture, then you want a non-exclusive. Exclusive licenses can also be divisible. If you have, excuse me, an entire line, let's say, of case goods and related upholstery products, and perhaps the manufacturer that you want to handle the case goods does not really care to handle the upholstery, then you might grant an exclusive license to manufacture the case goods and a second exclusive license to a second manufacturer for production of the upholstery. So there are a lot of different ways to approach that. For a period of 3 years. Many of the contracts that I looked over last fall, prior to doing the first seminar, did not include any period or specific term. There were many variations. Most of the approaches, hopefully, being that the designer would be paid a royalty for as long as the manufacturer included or was selling furniture that included the designer's designs therein. That's apparently becoming a thing of the past because manufacturers are preferring to put a cap or a ceiling on royalties paid to a designer, regardless of the possibility that the design might be good for 10, 15, 20, 25 years. They would prefer to pay for only a period of a few years, obvious reasons. The period defined here should be adequate for the furniture industry to demonstrate a manufacturer's ability and willingness to take a design and actually put it into production. If they do not do this within a reasonable period of time, you should have the right to withdraw your designs and take them elsewhere. But if a contract is negotiated and signed without specific attention to that term, then it's not beyond the realm of possibility that a furniture manufacturer might see designs that potentially would be good in the marketplace, but they have no real interest in moving ahead very quickly, and the designer is left dangling. So I would definitely want some type of term specified in any contract I negotiated. 3 years should give someone time to get through any type of production problems and demonstrate marketability or capability of getting it to market. Some would even say 2 years would be adequate, but I think 3 years would certainly be reasonable. If not, then you need to be looking elsewhere. Many furniture companies are taking the approach that we'll get a new design, we'll run it to death for 2 years, and then we're going to go on to something else. Now, this might be in the lower end or lower middle end furniture, more of the fad market, but it happens a lot. And if you're left with no recourse, then you're going to be the one left holding the empty pocketbook, not the manufacturer. Again, this paragraph should specify, as the previous second or third paragraph did, what the designer or what the manufacturer is getting. What is the designer providing in the way of support services? And is it only during the term of the agreement, or does it move beyond that? Second paragraph, the exclusive license granted in paragraph 1 above shall be subject to sublicense upon written request by the licensee. This goes back to the transferability that we were talking about in paragraph 1. It's not uncommon for a manufacturer to decide that we own the rights to this design, but we don't want to manufacture it, but John Doe company down the road might. That's all well and good. As long as someone's making your design, you're happy, right? You may not be. You may not be at all happy if John Doe company has poor quality control, poor business practices, is verging on bankruptcy. There are many reasons that you would not want a sub-license to a third party. You always want to have control over the right to transfer your designs to another manufacturer. Remember, in a license agreement, you're retaining full right and title to your design. You're only granting a license for someone to make and sell it. So you want to retain control. This is one area that you do retain control. You may choose to say it's not subject to sub-license. You would go back to the non-transferability that's specified in paragraph 1. But a good moderate ground is in paragraph 2, where you grant the right to sub-license when the manufacturer has written a request specifying the third parties who are interested, and then after your evaluation and your consideration of the third party, the specific third party, you may or may not, in your discretion, grant the right to sublicense. That is a minimum type of control. It would give the manufacturer the ability to sublicense if necessary, and frequently this happens. They may find for market reasons, for ability to obtain production goods. There may be any number of reasons that legitimately a manufacturer would want the right to sublicense a design, but it should not be done automatically and without your consent. Throughout the production of furniture, you should be attempting to remain a viable, active partner in the production of that design. Paragraph 3 relates to ownership of the materials that you provide to the manufacturer at the time the license is granted. It might be, as we mentioned above, as simple as drawings or even photographs of prototypes. But it might be as detailed as production techniques, working drawings, engineering drawings, consultation. All of these materials might include material that or information that you would prefer not to go beyond the manufacturer. So during the production of the goods, the manufacturer will have the right to these materials on hand in the manufacturer's premises. But at the time of expiration or termination of the contract, those materials and any copies of those materials should be returned to you. That's what this paragraph is spelling out. Paragraph 4 is a very simple, almost misleadingly simple statement of ownership of any patents which might be applied for and which might issue remaining in the hands of the designer, inventor. Quite truthfully, this paragraph would likely have to be expanded if used, if a manufacturer is going to look at it closely. Probably this paragraph will be expanded. What will happen, the initial patent applications or patents related to the design that is the basis for this agreement are generally not contestable as far as ownership. They belong to the designer, inventor, and a question, there would be no substantive question about it. However, frequently when you get into production, improvements might be made in the design. Certain changes might be made to the design that are necessary for production. Ownership of those improvements and changes is negotiable. If you are remaining an active part of the team, then there is a very strong chance that you will be the inventor of the design. However, if you are using the production facilities and the production know-how of the manufacturer, then at the very least, that manufacturer is going to have shop rights, not only through use of their facilities, but through this contract, to the improvements and to the changes that are made. So that paragraph is likely to be an area that would be expanded, and the ownership of the initial patents versus ownership of the design improvements and modifications would be negotiable. There are a lot of different approaches to take in that situation. It might be that any design modifications you would own, but they would be granted a royalty-free license to those improvements. It might be that they would own the improvements outright, or some hybrid, some combination of those two. Anything that either party openly and with clear knowledge of the circumstances and the relative advantages and disadvantages of the proposed approach. Anything that two parties agree to, as long as it's properly spelled out and both parties willingly and knowingly agree to it, then that's fine. There are no fast rules that say you cannot do this and you cannot do that. But you do need to be aware of the areas that will most frequently become issues. This is one of them. Now, we get to paragraph 5, which is a very basic royalty statement. Licensee agrees to pay to licensor a royalty equal to X% of the net selling price for each unit of product sold, which incorporates licensor's designs therein. Almost each phrase in that sentence is subject to interpretation. And when something is subject to interpretation, that's where the issue arises, which frequently causes problems. When you negotiate a royalty agreement, you don't want to do it from a standpoint of everybody gets 5%. 5% of net selling price. All right, how did everybody arrive at the figure of 5%? Is it 5% of a product that's going to sell for $5? And granted, you don't find a piece of furniture selling for $5 nowadays, but there are other areas of the world where you might have a product that's going to go out on the market for $5. And if you're getting 5% of the net selling price on $5, you're not going to end up with very much unless you're going to be selling $1 billion on it. And if it's not worth very much, then fine. But you have to know 5% of what. And if it is of the net selling price, then what factors are used in calculating net selling price? That should be defined within the contract. The second sentence in that paragraph says net selling price is defined as gross sales price after deductions of cost incurred in the manufacture, sale, or distribution of the product. This is a minimal definition. I've seen license agreements where the definition of net selling price was a page long, and it wouldn't be really unusual to do that. What I've tried to do here is provide you with something that is not going to scare a potential manufacturer to death when he looks at it, because suddenly he's faced with 10 pages of an agreement. The broad definition of net sales price would be your gross selling price, either at wholesale or retail, less any legitimate production, marketing, distribution costs. That's not hard to define, and that's generally acceptable to any party. Now, the percentage that you should receive should be based on, first, what do you think the design is worth in the marketplace and what you should be getting for it. And in order to get that amount, how many units must you sell, and how much of that selling price is going to be used in calculating your royalty. So it might range, probably if I had to give an average on royalty figures, they would range anywhere from 2.5% of an extremely high-ticket item to as much as 8, 9, 10% of a less expensive item. But I will say this, there is an awful lot of money left on the table by people who go in automatically asking for the percentage that they believe they should reasonably expect to get. If you reasonably expect to get 3%, and that's what you hear through the grapevine that everyone else is getting, and you go in and you ask for 3%, and there is any negotiation that goes on at all, you'll probably come out with somewhere between 1.5% and 2% if you're lucky. That's an age-old practice of starting high and leaving yourself room to come down. And although the other party fully knows that that's what you're doing, it's just one of those things that, one of those games that everybody plays. And it's very difficult to just cut right to the bottom line and say, let's cut out all of that. I want 5% and that's all I'm going to accept. So allow yourself some room. Try to go in well prepared with an argument to support the maximum figure that you're requesting. Don't request the whole pie when you're actually only entitled to 2/3 of it or half of it. But do have strong arguments as to why you should have that 2/3 or that 1/2. When you have those strong arguments, you then have room to negotiate and to throw out things that perhaps are not so important to you, but you're dealing from a position of strength. The third sentence, it says, such royalties shall be paid to the licensor on all units sold by the licensee or any of its associates, affiliates, or subsidiary companies, and shall include units utilized as free introductory offers, samples, premium items, or the like. Now, this is one area where inventors and designers can frequently lose money. If the royalty is based only on the net selling price for each unit of product sold and stops right there, then it's quite possible to find manufacturers who will manufacture the units, ship them over to a subsidiary, not mentioned perhaps in the contract or the agreement. The subsidiary sells them, and you're not paid the royalty because the party to the contract didn't sell them. Now that is a long shot. The days of that occurring, hopefully, are behind us, but such things do happen, such things have happened. It's also possible that a manufacturer will sell a certain amount of product, perhaps in order to meet a minimum royalty, and then the subsidiary or affiliated company will be selling the bulk or the remainder of the product, and you're not paid the royalty on those. So you want to specify that it's for each unit sold, each unit given away, so that you are getting the maximum royalty due you under the contract. Getting back for a moment to negotiation of the amount of the royalty, this is only one approach, and a very basic approach to establishing a royalty agreement. There are a lot of different approaches. You might have a design contract incorporated with a license agreement, wherein you would be paid a retainer for your design services and a royalty or perhaps a minimum royalty on sales of the unit. That's an approach that's used fairly often. There might also be a sliding scale of royalties where a company expects to sell a tremendous number of the product unit and does not want to pay the same royalty fee on each unit. Possibly you would have a royalty of, for instance, 8% on the first 5,000 pieces sold. On the next $5,000 to $10,000, perhaps a royalty of 7% or 6.5%, and it slides on down as the number of units sold increases. Your income is still increasing, but the manufacturer's profit margin is protected by such an arrangement too. And that's a legitimate concern of many manufacturers, and such sliding scales should not be dismissed lightly. Sometimes they can be very high income producing royalties. Here again, as many approaches to the drafting of a royalty clause as can be agreed upon between the two parties is acceptable, as long as each is fully aware of the terms and there are no hidden unethical situations. When you're setting your royalty percentages, as I said, you need to define net profit. You also need to define gross income from sales, if your royalty is based on gross income. Gross income from sales might include products of first quality, products of secondary quality, products that are sold in outlets when they're seconds and they go out of the manufacturer's plant. They can't go into the high-end retail shops, but they go down the road to the, what is it they call, freight transit damaged furniture, these areas. You should be paid a royalty on that also. We speak to that specifically in one of the subsequent paragraphs. But all of these definitions need to be included in the contract to the degree that you can get the manufacturer to accept them. Looking at page 3, paragraph 6, is the minimum royalty clause. I think I have only drafted one exclusive license, not only in furniture, but in any of the other industries that I work with. I think I've only done one exclusive license where there was no minimum royalty agreement included. This is a protection to you. If you are granting someone an exclusive license agreement, the courts have said that the licensee has an obligation to use his or her best efforts to bring the product to the market and to sell a reasonable number on the given market. But they don't have to, and there are many ways for someone to demonstrate a best effort. Which best effort failed and left you as a designer with your designs tied up in an exclusive license and no income on it and no way to get them back and get them to another manufacturer. Where a company wants an exclusive right to a design, that company should, and in most instances does, expect to pay a minimum royalty. Now that minimum royalty would be defined in various and sundry ways. It would be, again, your knowledge of the market, your estimate of what the market value of that given design is, and what your share of that value should be. That minimum royalty should be paid yearly. When we get to the paragraph on payment of royalties, the monthly payments would be, of course, applied against that minimum. But it protects you not only in the ways I just mentioned, it also protects you again from the manufacturer that for whatever reason, and there are many, will decide, I don't want that design, but I don't want anybody else to have it either. Therefore, I'll take a license to manufacture. I will demonstrate the best effort to get it to a market, and I'm going to fail, but I'll still be able to show my best efforts. And I don't have to pay a penny for it. That happens. So that's why in order to sit on a design, a manufacturer should at least be expected to pay for the right to sit on it, and that is through a minimum royalty. Paragraph 7. In the event that the royalties due licensor for any annual period under this agreement do not at least equal the minimum royalties to be paid under paragraph 6 above, licensor shall have the right at any time within 90 days after any royalty report demonstrating said failure to give licensee 60 days notice of intent to terminate. Now, these 90 days and 60 days are somewhat arbitrary. However, you should be able to realize in a 90-day market period that things aren't going anywhere. You've got that 90-day period. I think we're ready now. We go on with paragraph 7, related to the licensor having the right to terminate when it becomes apparent that minimum royalties are not going to be met. This is not something that automatically happens. You don't trigger a switch and the contract immediately terminates. This 90 days is a period of observation. You receive a royalty report, a monthly payment. It's very low. Your previous monthly payments have been low. And it doesn't take a rocket scientist to calculate that by the end of this first annual period or this particular annual period, at the current rate, you're not going to meet your minimum royalties. From the date of that report, you have a 90-day period to observe and make a decision as to whether or not you're going to seek termination. It's not saying that you have to wait the full 90 days to do it. It's just that you have a 90-day period to do it. When you give the written notice of intent to terminate, you give the licensee a period of time. I've specified 60 days. That's generally reasonable. It could be 30, it could be 45, it could be another 90. It depends on the peculiarities of the relationship. During that period of time, the licensee is going to have a right to cure or a right to give you a reasonable assurance that the minimum royalties will be met. It is advisable under these circumstances to work with the licensee. You don't want to alienate. There might be any reason, particularly if it's in the first annual period of a contract that's going to go on for a few years. There could be any number of market reasons that would cause the initial royalty payments to be low. And you want to use that period of time to be cautious, to be aware, but not to be unreasonable. So this 60-day period after you decide to terminate or to give notice to intend to terminate, the licensee will give you, if available, reasonable assurances that the contract will be honored and that your minimum royalties will be paid. But this is a paragraph that I don't really think you should omit, because in those rare instances where, for whatever reason, it's not going to be possible for the licensee to meet the obligations under the contract, you should have a way out. This is one of them. Paragraph 8, payment of royalties under the agreement shall be made within 10 days after the end of each calendar month during the life of the agreement, and shall include a statement identifying the number of units sold during that month and the dollar value of sales volume. Very simple. It can be payable quarterly. anything that you and the manufacturer agree upon is, this is one of the simpler paragraphs. You don't want to be unreasonable, but you do have a right to protect your cash flow. If you need it monthly, then that's where you start. But there are some instances where it's paid annually. It's entirely up to the parties. I do want to point out the fourth line shall include a statement identifying the number of units sold during that month and the dollar value of sales volume. This is to alleviate any problems with number of units sold not being equivalent to the expected dollar value. When you were negotiating your royalty agreements, your royalty percentages, obviously there was some criteria for establishing that royalty. And number of units sold alone or dollar value alone may not be sufficient indicators as to whether or not the contract obligations are actually being met, but the two together should give you a good picture of what's going on from a month-to-month basis. Paragraph 9 is an optional, but it's something that I think in talking with designers and in seeing sample contracts, apparently it's a common business practice for designers to assist at market or in other phases of marketing, and you want your expenses to be paid. That's all that relates to. It can be deleted, it can be expanded, it can be calculated into royalties and you absorb those expenses, but it's certainly something that you need to be aware of and have covered in some way. 10. Licensee agrees that licensor shall have the right to a periodic examination of such books of account and records related to the sale of the subject matter of this agreement. That is standard business practice, something that you should expect to have the right to do. It should not be abused, absent any indication that there is foul play. You would normally not expect to audit a licensee's books any more than once a year. Maybe not once a year, maybe every 2 years, or at the end of the agreement, just prior to termination or expiration. But you do want this clause here. I do think that at least yearly, you should get the detailed statement that's outlined at the top of page 4. Licensor should be given a detailed statement by an independent certified public accountant showing the number of units produced, the number of units sold, the gross sales price, and any itemized deductions from gross sales price. Number of units produced versus number of units sold goes back to what I was saying a minute ago about the monthly statement that you should get. This is the only way to get a valid comparison and a valid indication of what's actually going on in the manufacturer's facilities. If they're producing a lot of units and they're using them as premiums and they're not selling them and you're not getting your royalties, you want to know that. So you need to spell out those two items. The gross sales price, again, we've talked about that, and all itemized deductions from gross sales price, so that you can see if there are any hidden factors that are costing you royalties. The last sentence says that all books of account and records shall be retained for a period not less than 2 years after expiration or termination of this agreement. 2 years is certainly a reasonable period. You might even expand it to 3 or 4 years. There are circumstances where you might not become aware of the possibility of lost royalties until after a year or two. And at that time, you do want to be able to go back and review records. Paragraph 11. if royalty payments to licensor are in arrears for a period of 30 days after the date due, or if the licensee is adjudicated a bankrupt, or becomes insolvent, or if licensee otherwise defaults in the terms of this agreement, licensor shall have the right to terminate upon 60 days written notice to licensee. This is similar to the paragraph above related to failure to meet minimum royalties, but it is not identical. So therefore you do need both. This gives you the option of terminating in the event that even where your minimum royalties have been met, there appears to be trouble coming and the contract is not going to be, you're not going to get the return on the contract for the balance of its term due to bankruptcy, insolvency, poor business practices, whatever. You then have the 60 days. Now here again, the licensee has a right to cure these defaults. And where they are able to cure, then you have an obligation to honor the balance of the term of the contract. But this does give you a way out. Paragraph 12. This agreement will automatically renew for a like period unless, at least 60 days prior to expiration, either party gives written notice of intent not to renew. This is a fairly standard clause added to license agreements in a number of industries. I am not sure how often this automatic renewal is applicable to furniture designers. And I would like, without losing too much time, to ask if anyone has a contract that's automatically renewable. Have you used one in the past? Okay.
Every year.
Pardon?
Every year.
Every year.
It's open-ended.
Yours is open-ended. Okay. Are open-ended contracts the predominant, or is it something that's just not spoken to at all? Not spoken to, there's open-ended, okay.
Don't you have to have a finite term to make a contract binding in payment?
It can be applied. It's not good to have it.
Well, finite in terms of 1, 2, or 3 years and then renewable, as opposed to just saying we have a contract.
A contract, in order to be whole, needs a period of onset and a termination clause, yes. But where that is eliminated or forgotten, there are certain circumstances that will imply a term. So it will not be automatically void for lack of such a paragraph.
As long as product is manufactured.
That's great, and that goes back to what we were talking about earlier, if you can get it and if they're not going to put a ceiling on it. But apparently it's becoming a common practice
Not to.
for the manufacturer to say you're going to be paid royalty for 5 years, whether we're selling it for 20 or not. Paragraph 13, this agreement shall be interpreted in accordance with and governed by the laws of the state of X. This is a clause that needs to be considered in the light of possible arbitration. Arbitration is a very popular approach to settlement of disagreements. It is certainly a viable, good approach to settlement if the terms of the arbitration are spelled out adequately in the contract. It's unfortunate that when arbitration became a viable mechanism, I guess really I'd have to say attorneys probably screwed it up and have made it almost as expensive now to actually go through arbitration as it is to go into the general courts. But if you elect not to have arbitration, then you want a clause that will say the contract is going to be governed by the laws of the state that's most compatible with you, whether you're physically located in the state or whether you have a principal place of business in the state and that state is more lenient or will be more supportive of the design position. These are the types of things that would determine. But if you're doing business strictly in one state, it's where you are physically located and your principal place of business is physically located in that one state, then that's where you want the contract governed. You don't want to have to try a case out of state if you can avoid it. But arbitration is certainly something that should be considered. I did not include an arbitration clause because I think arbitration is subject to a number of problems. It definitely needs to be balanced against all of the other factors involved in enforcing a contract. Paragraph 5. This writing constitutes the entire agreement between the parties and supersedes all prior agreements and understandings, written or oral, hereto. No modification shall be valid unless made in writing and signed. This is directly related to what is known in the legal system as the parole evidence. Where this clause is not included, the door is left open for submission of various types of oral and written evidence, or oral and tangible evidence, in support of arguments on either the side of either party. That can sometimes get really messy. And it's a little bit cleaner, generally, to make a statement agreed upon by both parties that this contract incorporates all that we've agreed on, all that we've discussed, and that if any further interpretation of the contract is desired or is going to be sought by the courts, that interpretation is going to be made within what is called the four corners of the report. In other words, that paper is what is going to be used. It's just a much cleaner approach, and I would suggest that you use that in your contracts. And then you have your simple signature, and North Carolina is one of the only states that still consider or still uses a seal. That's why that is there. In some states it's totally unnecessary. I don't know whether any of you have submitted questions or have written them. I think we now have about 30 minutes that we can utilize. If you will forward them to the front. Just give me one off the top and I can be approaching it while you're going through the ballots. That one will save a little time, maybe.
Sure.
Is granting of an exclusive license considered a sale of an asset for capital gains consideration? Depending upon the tax structure and corporate structure of your business, it can be, and particularly where the exclusive license is tied to patenting. You've got design or utility patents, then it certainly can be considered a sale of an asset. That is best answered by your CPA or your tax attorney who knows your business structure, because there are various ways of looking at it, and the tax laws change now year to year, and I really could not give a blanket answer for each of you that would be applicable to each of you, but certainly it can be, and if it's a patented article, it probably would be. Second question is, can interest be charged on past due royalties? 90% of the time, yes. Particularly if you have to go into small claims court or general courts to collect past due royalties, then yes, you would automatically request that interest be applied. And I would not suggest at all that you be considered a banker to carry manufacturers. That is one reason for the paragraphs related to default. If the royalty payments are not paid on a monthly or quarterly basis as agreed upon, then you have some recourse. And at that point, if you chose to seek interest rather than termination, you could also do that by a written addition to the contract. A lot of approaches you could take, but yes, you should not be expected to bank someone else. And that's happening nowadays. Boy, I tell you, corporations that used to pay in 30 or 45 days are now paying 60 and 90 and 120 days. A lot of us are expected to be bankers. Oh boy. Can a factory change hardware or finish or other minor changes, such as make a case longer and call it their design? And how do you protect against this in contract language? Designers are protected preferably by patents, but recognizing that that's not an inexpensive process, and many times we prefer to test the market before seeking a patent. We then have to fall back on unfair competition claims and unfair trade practice claims, which might be state or federal. Where there is a patent in existence, such minor changes as finishes and scale would not avoid the patent. Hardware might. If it's a design patent, number one, and let's clarify, we're not talking about utility, we're talking about design patents. If the design is strengthened because of the particular hardware, or if changing the hardware affects the overall appearance of the cabinet or whatever the piece of furniture is, then possibly they would avoid the patent. But that's not something that there's just a yes or no answer. That is one change, though, that could affect patentability if the hardware is a substantive part of the design. 1 second, okay? Making a case longer or changing the scale of a chair. Again, if the article is patented, most times that will not avoid a patent. However, there is case law to the effect that if changing the scale of a chair affects the overall appearance of that chair, then possibly the potential infringer has avoided your patent.
Well, we ask questions from the floor related to the topic that you're discussing.
Sure.
I find that design patents in the furniture business are probably restricted to the designer. They are negative impacting. Better not to tie a contract to a design patent for the reasons you mentioned. We've used the words derivations thereof following any submission that we made. We've never had a test in court. We've had manufacturers back down when they have done those things you said. We said those are derivations that you even cleared with us. Even if they haven't, the same sort of thing. The derivations there seem to satisfy the manufacturer that they should watch out. They can't just abstracted a bit and not past royalty.
That certainly is helpful, yes. But it's unfortunate that still, the only thing a designer can really fall back on that has much clout, and that's improving too. The courts are beginning to be much more supportive of the patentee. That's when you get into unfair competition claims and unfair trade practice claims, at the very least, it's expensive litigation. At the very least.
When you have a question of the derivation of or unfair claims, if your contract called for a product which includes the design or a product derived from the design, then wouldn't the manufacturer's change be contested just under contractual agreement rather than unfair practice? In other words, isn't he merely violating the contract at that point?
Well, if I were going to represent a designer who had that situation, I would look not only to breach of contract, but I would look to unfair competition claims also. I would throw out everything I could find in the statutes that was reasonable. Because somewhere I'm going to catch it.
I'm sorry. I was trying to keep you from having to read the same question twice. There's a report there that you can just read.
What is your opinion regarding a general license agreement to covering the overall relationship and adding new designs under separate agreements stipulating royalty percentages? There's nothing wrong with that at all. That would be quite feasible in a relationship that was ongoing over a period of years. I would see that probably being an efficient way to handle it, where the parties have a good relationship and a history of doing business together. I don't know that that's the way I would start out necessarily, but it's certainly something that's viable. What are your feelings, pro and con, about manufacturers putting a time cap on royalty payments? Got any manufacturers in here? Oh gosh, I represent manufacturers and I represent designers. My predisposition over the years has been to the designer. I don't really know why. It just has been. I enjoy the creativity, but I also recognize that manufacturers have legitimate business concerns. It has always puzzled me though, and I have asked some of them, and I've yet to get a good answer or one that satisfies me. When a manufacturer is making good money on a design or on a sales staff, and without that design or without that sales staff, they probably would not be making such good money. When they decide that they need to increase their profit margin, where do they cut it first? They cut it at the sales staff or at the designer level. I don't understand that. To me, that is the poorest business logic imaginable. And I don't, therefore, particularly like time caps on royalties. And I don't think that you ought to accept them absent some damn good reason. But I realize that they are a reality and you've got to operate in the real world. So I can't say that you won't be faced with them and you won't have to accept them in many instances, but I don't understand the logic when they're making money on your design for 15 years or 10 years or whatever, why you should only be paid 5. I just don't. Are you going to explain it to me?
Well, actually, I'm the one that asked the question.
Okay.
But when someone approaches me that way, what I usually say to them is, I'll be very happy to reduce my royalty by X percent, and you will reduce your profit by precisely the same percentage.
Mm-hmm.
And that way they can achieve it. That usually, they never take you up on that offer.
No.
But I concur with what you said, that so long as you're generating income for them, that you have a right to collect a commission. Just the same as if a salesman sold it, the manufacturer is presumably making a profit on it. I think there's no logic to justify.
There isn't, other than their desire to make more money. And to me, I think if I were in that position, I would want the best cared for, happiest sales staff and design staff I could have. Because if they're not happy and they're not selling or they're not designing, then I'm not going to make anything. But what do I know? Maybe if I were a manufacturer, I'd feel differently. I don't know. You have no contract with the manufacturer. He, in fact, refuses to sign one. However, he has paid you the agreed-upon royalty for a number of years. Does this constitute a verbal agreement or contract, whatever? Certainly, you can look to prior business practices and prior trade relationships to establish the implication of an oral agreement. You certainly have enough to rattle their cages. And sometimes they would prefer to go ahead and pay you than to silence the cage rattling, because that's expensive on their part too. It's not foolproof, but you certainly, where you can establish prior trade practices, you've got an argument, and it's one that you could certainly use. Any other questions related to that? I see a lot of people, apparently it's a problem. Does the designer need to assign patent rights to qualify IRS for capital gains, or can one only have a license agreement, royalty, income? This is related to the question that we took before, and you really need to talk to your tax attorney about your whole business structure, because there's so many ways to do it. Is there any way to keep a license from entering into the bankruptcy with the company which goes into bankruptcy? Yes, if you want to. If you choose, now, this contract approaches bankruptcy by giving you a right to terminate. If you would prefer to have your contract considered, or your license agreement considered an asset that gets tied up in in bankruptcy court, you can delete this right to terminate and then hope that when the trustee is appointed, the trustee will consider that an asset, and that if there is any reorganization of the business structure, that asset will be transferred to that reorganization. But that's really dangerous, and it's not something that I would recommend that in any circumstance I can think of right now. Yes.
Is it possible to, when drafting the agreement, to make yourself, rather than agree, a secured creditor so you have a better chance in a bankruptcy proceeding?
Well, actually, secured creditor status, if you think that you're going to be left holding the bag for a lot of outstanding royalties, yes, you can do that. The better practice would be to stay on top of the royalties month to month or quarter to quarter, because even when you are a secured creditor, there are ways to lose your money, and it frequently happens. Now, back here.
Have you in fact had it adjudicated that this paragraph 11 will take effect before the bankruptcy court actually says that your designs are assets of the corporation and passes them on to bankruptcy and says, I'm sorry, even though you said as soon as the bankruptcy is filed, this is null and void? Because we have a situation, we have basically the same thing. Said if they go to bankruptcy or file for bankruptcy, this contract was terminated. The bankruptcy court said to us, you're crazy. That's an asset of the corporation coming in, and you can't have a determination before the filing, and as soon as it's filed, it's part of it. So what's the catch-22?
The catch-22 is that from judge to judge in the bankruptcy court, you might find one, or you might find several, who would say that because of this clause, that you do have a right to terminate. But what you need to do is to monitor your accounts closely all the time, because you're going to have indicators long before they ever get to the bankruptcy courts. You're going to have indicators that that's where they're heading. And it's at that point that you need to be starting the termination procedures under this clause.
But they were smart enough to live up to paying us on time, showing things. But what happened was, once they went into bankruptcy and their designs are no longer, they stopped producing, while it's still in the 11, there's no way to get those valuable designs out of there until the manufacturer goes into the Eon. That was what the problem was, not the payment.
Some judges would have handled that differently.
That's my problem, thank you.
I do know of 2 instances where not a furniture designer, okay, but another industry, where the licensor was able to move on to another manufacturer. But I cannot say that it is something that would happen in every instance, no. Heirs and successors. Certainly that can be added. And it's a very simple thing to add. It's not, there again depends on your business structure. There's no real reason not to have it. There really isn't. It's in a number of contracts. It's deleted from an equal number. And I quite frankly don't know of instances where it would be undesirable, specific instances where it would be undesirable, absent some personal situation that the individual would be aware of. So there's no reason for it not to be included. Most contracts for assets of this type, though, and certainly if there's a patent involved, even without the specific clause, would transfer into the estate or to the heirs. I need some help, a little elaboration. As professional designers, how can we legally start an association as the MEDS have?
Medical association.
What? Are you talking about the American Medical Association? Well, you have the American Society of Furniture Designers. I'm not sure I'm following what.
Well, I guess maybe I'm talking about more like the union, more or less.
Ooh.
Your word?
Where is that Stillman fellow?
Look at him.
I'm going to avoid this one if I may. It's obviously that you need to find other people of a like feeling and set up an organization. I mean, that is a clear-cut way to do it. I think probably you would be more successful, though, in working within an organization that's not called a union and becoming partners with the manufacturers, seeing that both have a lot to gain from cooperation instead of antagonizing and the constant battles that have been the history. He says, as you referred to ceilings being put on royalty payments as common. In my experience with 10 to 15 firms, I've only had it proposed to me once. In that instance, I rejected the idea and chose not to work with that manufacturer. Ask for a show of hands to see how common this idea is, how often is it proposed, and separately accepted. How many of you have had ceilings proposed? Quite a few. How many of you declined to accept it? Good.
Some, yeah, some from some and some not.
Okay. I don't think this is the time to get into the criteria for accepting or declining sealing. That's probably another whole discussion. Regarding paragraph 3, defining proprietary materials, if you've developed a technique which use is necessary to accomplish your design, do you need to document the technique? If so, how should we document? Absolutely, it needs to be documented, and it depends on what the technique is. If it is something that can be subjected to reverse engineering, a mechanical device or an operation process that would be easily detected by parties that you would prefer not to have the information, then you need to look to the clear establishment of a trade secret. And to establish trade secrets, there are specific criteria set down by the court as to limiting access to parts of the plant where this process is done, limiting access to the details of the procedure or the product. There are a lot of very specific controls placed on how you disseminate the information and to whom. It should be under a confidentiality agreement clearly outlining what the information is. If it is something that is peculiar to one piece of furniture, one production method, and that is going to be a part of your contract, then that needs to be spelled out very specifically, and I would have a separate paragraph relating to the usage of that information and the controls that would be placed on it. But trade secret law and proprietary information is becoming almost as viable in many environments as patent protection. You're going to see a lot more of it, but there is specific criteria related to how you establish it. What about payments to your estate after death that we touched on briefly a moment ago? There's certainly no reason not to include it in the contract.
I have a question about that
Okay.
subject. If your contract is between the manufacturer and your corporation, do you need to have a paragraph about the survivors written in? Or does the corporation cover the income after
And your
death?
license is an asset of that corporation.
Yeah.
Then certainly all of the implications would be there that it would go to your successors if you're heirs, but there is really no reason not to spell it out. What percentage of your contract writing is for designers, manufacturers, sales and marketing organizations? Okay, I do very, very little for sales and marketing organizations. Most of what I do for them falls in the area of trademark work. My trademark work probably is 30% of my overall practice. Designers, since I went into practice for myself, probably I work with designers as compared to manufacturers, probably 80% of my time. There's still some manufacturers who I represent, but the predominant part of my practice in this industry is related to designers. Has anyone ever audited my clients' books? Relative to clients in litigation, yeah. That happens generally if it gets into full discovery. You will find some auditing procedures. Of course, there are various sundry ways to handle that. You can ask that they be audited by a third party and that the audit results not be available to the opposing party until it's proven or until it's decided by the judge that it's necessary and pertinent to the case. In other instances where there have been audits involved, if you're talking about specifically where you audit for payment of royalties, as we discussed in the contract, fortunately, that has not been an area of a problem. Generally, when I've had litigation occur relative to a license agreement. It has not been in the payment of royalties, but it has been somewhere in the breach, maybe a ceiling, such as we've talked about, or who owns what relative to patents. That sometimes gets to be. And also there's something not spoken to in this contract purposely, because so few of you seem at this point to be utilizing patent protection. Although I've got a paragraph in there about ownership of patents, there's nothing in here related to who will pay the cost of enforcing a patent in an infringement circumstance. If you have patents, that is definitely something that needs to be in your contract. If the manufacturer is going to pay for enforcing the patent, if you're going to pay, if the two of you are going to do it together, there are many, many approaches taken to that subject, but it's certainly something that should be clearly spelled out if you are a patentee. If we phone you with questions, what are your terms? Is this a special rate for ASFD members? Okay. I honestly have a tendency, I think sometimes, to give away more information than I should. I really do. I don't know why, but it's not that I'm just such a wonderful person. I just sometimes do it. But I charge for strict consultations by the hour. If it's negotiation of a license agreement, it's probably going to be a hybrid between a flat rate and an hourly rate. It will depend on whether it's a very simple, very basic agreement such as this. It'll be done generally on a flat rate. If it's something where I'm going to be sitting down at a table for hours with another bevy of attorneys and we're going to be really hammering out something, it's an hourly rate. Telephone consultations, generally I'll talk to anybody for 15 or 20 minutes without charging. If you actually go beyond that and you need some specific thing done, then we talk about that at that point. But I don't have any hard and fast rules. And I don't charge for phone conversations that last 2 minutes.
I have a question pertaining to that. Do you find that it's that your attorney should sit in with you when you're negotiating with the manufacturer?
The attorney should sit in with you prior to getting to the table to decide what strategy is best.
I understand that, but what about sitting in during negotiating?
It depends on the circumstances. It really does. I have some clients who are very, very adept at negotiating contracts.
What if you're not?
If you're not, then yes, I think you probably need an attorney with you.
That doesn't alienate the client?
It shouldn't. It should not, if it's handled properly. Now, what I was saying is that being part of the strategy. If you are adept at negotiation, or if you have a party who, for whatever reason, is really skittish about having an attorney present, then I would weigh two things. Number one, why? And number two, how much I need to do business with this party. Attorneys can muddy water, sure we can. But sometimes it's water that needs to be muddied. I mean, in the rush to make a deal, and in the rush to get our product to the market, we sometimes are willing to accept a whole lot less than not only that we should, but that is available. And it's not at all unusual for a very creative person, such as an inventor or a designer, to not really be aware of all the things that are available to the party, to that party. So that's where I think an attorney does a good job by being there. But if a person really handles negotiations, sometimes an attorney is more harm than good. The present trend in big-time negotiating, big-time license agreements, is you have a team. You've got an attorney, but you also have a couple of the business partners, and you may have a special person come in as an employee or as a consultant, not an attorney, but to do just that negotiation. Yes, Ellen?
In that regard, in the listing of the 4 types of contracts, has the organization asked you to put those together, or do you have a standard form of such confidentiality disclosure what's your recommendation on those other three, or at least the first two that you listed in your initial letter?
Okay, I have a starting point in my files for each of these. I almost never pull that out of a word processor and send it to a client without any change. I don't think, it's done a lot, and it would be very easy for me to say, okay, for a confidential disclosure agreement, you send me $100, and I'm going to send you this blank contract, and you can take it to whomever you please. There's nothing illegal about that. I just don't think you've gotten much for your $100. Now, the organization has not requested that I prepare these others, no. But that's why I had the caveat on this license agreement. It's a starting point on
Well,
that.
yes, those would also be starting points.
Yes.
I just wondered if,
No, I have not been requested to do that, no.
This goes back to an earlier question, but bear with me a moment. I think all of us in this room know that design is essentially an evolutionary process. We submit ideas, the manufacturer likes the ideas, and then from that point on, the design evolves based upon the manufacturer's facilities, changing market and style conditions. With that in mind, this licensing agreement does not contain a clause which states that at some point the designer approves the manufactured sample or prototype and agrees that this is the quality that's acceptable to him. If that were in the contract, then it seems to me that that would protect a situation that was mentioned earlier, whereby a design is given to a manufacturer, he changes it, makes it larger, changes the hardware, whatever he does to it, and then the question comes up, is it his or is it the manufacturer's? If the involvement of design is mutually agreed to and covered in a clause in the contract at a given point, then all parties know that. And if the changes are actually on paper, and such as a blueprint which shows the changes, both parties can initial it and say that on this date, this is the final version of it, and it's acceptable to both parties, and that the manufacturer has an obligation to maintain a given quality as exemplified by the first samples. This contract does not have anything of that nature in it,
It does not.
and most of my contracts have had in the past.
Okay. Is it a common practice for the designer to work hand in hand with the manufacturer during the manufacturing process?
Definitely. During the sampling process.
Okay.
Yeah.
Prototype.
Through prototype
It's called
stage?
fine tuning.
Fine tuning, okay. How frequently do you run into modifications?
Always.
99%.
all the times. 3 or 4 times a day.
What are most of those modifications based on?
Whims of the manufacturer.
Is it to do with price, reducing costs?
The office staff.
Cost, facilities, time,
All of
all those
these.
elements.
But the secretary.
All right, now let me ask you this. When they're changing the design, or when they're making these modifications, are they actually changing the overall appearance of the design as you submitted it to them?
Sometimes.
Somewhat. Could be.
But not as much as just making manufacturing changes that may or may not be visible in the finished piece of furniture?
That's often very visible.
Often? Okay.
I think the way that I try to control is as follows. I'm open to any changes or any suggestions by anyone, from the president of the company to the person who sweeps the floor. But the way since we as designers are responsible for our designs, that's what people pay us for, then what the final thing has to be that we approve and are involved in the changes and have control of them, so that the product may be different from what it originated for a variety of reasons. Sometimes it's improved, it has happened too. But that this evolution has to be under the control. The design element of what it looks like has to be under the control of the designer in conjunction with the cooperation of the manufacturer, so that we can then say, yes, this is our design, even though it may have changed, sometimes substantially, sometimes minimally. And in that way, you can feel responsible and be proud to put your name on it.
Judith, may I just add something to what Merle was
Sure.
saying? And I hate to be the last person to have to say so, but our time is almost up. Just to follow up with what you're saying, though, I take a slight exception to what you said in that one part you put in there about even from the person that sweeps the floor up. Here's why. All of the problems that we've discussed for the last year, you and I, and everyone that's been involved here, I think basically what all of our problems kind of center around is the fact that there's very few other industries where manufacturers pay someone to do something and they don't give them the final say-so. I don't think my situation is unique where you have a sample that's brought in and there's the super salesman from 3 different areas, the vice president, and the guy that makes the samples or sweeps the floor, and in an effort not to look stupid or like they're getting paid for doing something and they're not, everybody suggests the change. Everybody that goes in to look at the sample says it should be a ½ inch taller, a ½ inch shorter, or a ½ inch. And they do this, I think, for the reasons I just mentioned.
Everybody.
I think that is one of the reasons that designers are not, it's sort of a self-perpetuating problem. We design something and then everybody wants to change it. We end up, well, hell, they didn't do it anyway.
Okay, let me just try very, very briefly to respond to what you were saying. My position on contracts is that the more that you have in them, the more you have to use against the party and the more the party has to use against you. Okay? It is very, very hard to define all of the possible changes that could be made in this evolutionary process and define who owns those particular changes. Now, I am not saying that you should not have a paragraph of this type. But sometimes when it isn't spoken to, you have just as many options as you do when it is spoken to. And I know now I have really muddied the water. I'm sure of that, and God knows it's going to go down in history on this tape. But it's really, it can be a can of worms. It can be a can of worms. And I'm not saying that you shouldn't have it, but I would want that paragraph structured very, very carefully. And that's why it's not in this, or anything like that, in this particular one. Okay? Thanks.
Like to say in closing?
I don't think so. I will be available here a few minutes afterwards for questions if you have some. I really enjoyed it. Thanks for the
Okay, thank you.
opportunity.